Welcome. In today's webinar, we will be diving into the topic of immigration waivers, covering the main type of waivers, who might need them, and what the application process generally looks like. Immigration can be complex, and waivers are essential tools that allow people to overcome certain challenges or ineligibilities in their cases. An immigration waiver is essentially a form of legal forgiveness granted by the U.S. government to applicants who would otherwise be deemed inadmissible and ineligible to enter or remain in the United States. In the immigration context, inadmissibility means there are specific grounds defined by U.S. immigration law that prevent an individual from being legally allowed to enter, stay, or adjust their status in the United States. These barriers can include past criminal offenses, immigration violations like overstaying a visa, prior deportations, or even certain health conditions. For example, a waiver can provide a solution for a person who entered without a visa but wishes to apply for a green card based on a marriage to a U.S. citizen. Without the waiver, this individual might face mandatory time outside of the United States or outright ineligibility for their green card. A waiver essentially enables eligible applicants to apply for forgiveness for these violations or issues by demonstrating certain factors such as the severe impacts their absence would have on a U.S. based family member. The government may, on a discretionary basis, grant a waiver if the applicant can meet specific legal requirements. This might include proving that their U.S. citizen or lawful permanent resident relative would experience extreme hardship if they were not allowed to remain in or enter the country. Each type of waiver is designed to address particular grounds of inadmissibility, and each has its own eligibility requirements and legal standards. Overall, waivers are crucial for people facing serious barriers to entry or status in the U.S., offering them an opportunity to overcome past issues and pursue a legal immigration path. Let's go over some of the main grounds of inadmissibility and how a waiver can provide a path forward. Let's talk about health related issues. Health related inadmissibility can apply to individuals with certain contagious diseases that may pose a risk to those here in the US, or in some cases, a lack of required vaccinations could also make someone inadmissible. For example, someone with a communicable disease like tuberculosis might be barred from entry to protect public health. However, a waiver may be available if they can show that they have received appropriate treatment and are no longer contagious, or that they meet other health related standards set by U.S. immigration authorities. In these cases, waivers help people who are otherwise healthy enough to live in the U.S. to overcome these medical barriers. Now let's talk about criminal convictions. Criminal history is another significant grounds for inadmissibility. Certain offenses, such as drug related crimes, serious felonies, or multiple minor offenses, may automatically disqualify an applicant. However, waivers can sometimes help individuals with a criminal record gain eligibility if they meet specific conditions. For example, they might need to show rehabilitation or that their crime does not fall under certain categories like aggravated felonies. Additionally, the applicant often must demonstrate that their presence is crucial to a U.S. citizen or permanent resident family member who would suffer extreme hardship if the applicant were not allowed to remain in the U.S. Immigration violations, such as unlawful presence, is another form of inadmissibility. Immigration violations, such as entering the U.S. without proper documentation or overstaying a visa, can result in inadmissibility and bans from re entering the country for several years. For example, someone who stayed in the U.S. beyond their authorized period may face a 3 or even 10-year bar, depending on the length of stay that they stayed past their allotted time. In these cases, an I-601A or other waiver can provide a solution, especially if the applicant is married to a U.S. citizen or has another qualifying family member. The waiver requires proof that the U.S. relative would face extreme hardship if the applicant were denied reentry, helping families stay together and allowing applicants to seek legal status. Misrepresentation or fraud is also a ground of inadmissibility. Misrepresentation or fraud occurs when an applicant has provided false information or documents to U.S. immigration authorities at any point in the immigration process. For instance, someone who used a fake passport or provided incorrect information about their background might be barred based on this history. However, a waiver for fraud or misrepresentation may be available if the applicant can prove that a U.S. citizen or lawful permanent resident family member would suffer extreme hardship in their absence. The applicant must typically show that their intentions were not harmful or that they have taken steps to correct past misrepresentations, allowing them an opportunity to apply for legal entry. Without these waivers, individuals facing one or more of these grounds of inadmissibility would be unable to enter or stay in the U.S., even if they have a U.S. based family or qualifying circumstances. Waivers provide a pathway for individuals to overcome these issues by providing that their presence in the U.S. is in the best interest of their families or that they meet specific criteria outlined by immigration law. These waivers are crucial in helping individuals overcome past obstacles and build new lives within the U.S. legally. Now let's talk about the specific waivers. The I-601 waiver. Waiver of grounds of inadmissibility. The I-601 waiver or waiver of grounds of inadmissibility is often used by applicants who are facing serious barriers to obtaining a visa or adjusting status due to issues like certain criminal convictions, health related grounds, or immigration violations. To be eligible for an I-601 waiver, the applicant typically must demonstrate that their U.S. citizen or lawful permanent resident spouse or parent, or in some cases, child, would face extreme hardship if they were denied entry or forced to leave the United States. Extreme hardship can be financial, emotional, or related to specific special medical or family needs that would make the relative's life difficult without the applicant's presence. This waiver is essential for those who would otherwise be permanently ineligible for entry, allowing them a path forward under specific qualifying conditions. Now let's talk about the I-601A waiver application for provisional unlawful presence. The I-601A waiver, also known as the Provisional Unlawful Presence Waiver, is available for individuals who are already in the United States but accrued unlawful presence, which could trigger a 3 or 10 year reentry bar if they depart the country. This waiver is particularly valuable for individuals married to a U.S. citizen or lawful permanent resident. It allows them to seek a waiver before leaving the U.S., minimizing time spent abroad and reducing family separation. Like the I-601 waiver, applicants must prove that their U.S. based spouse or parent would suffer extreme hardship if the waiver is denied. If approved, they can travel to a U.S. consulate abroad to complete their immigrant visa processing with greater assurance of being allowed back into the country. Now let's talk about the I-212 waiver, permission to reapply for admission after deportation or removal. The I-212 waiver is specifically designed for individuals who have been previously deported or removed from the U.S. and are barred from reapplying for admission for a specific period. This waiver provides a way for these individuals to seek permission to re-enter the U.S. before the mandatory wait period is over. To qualify, applicants often need to show positive factors like rehabilitation, close family ties in the U.S., or a significant reason for needing to return. If granted, the I-212 waiver allows them to overcome their reentry bar and resume their immigration process, whether for a family based employment or other qualifying purpose. Now, let's speak more in detail about the eligibility criteria for waivers. Eligibility for immigration waivers usually centers on three key factors: the presence of a qualifying relative, proving extreme hardship, and gathering substantial supporting evidence. Let's start with the qualifying relative. In most waiver applications, you need to demonstrate that you have a close family member who is a U.S. citizen or lawful permanent resident, typically a spouse or parent, and in some cases, a child. This relative's connection to you forms the foundation of the waiver application, as it is their potential hardship that the U.S. government considers when deciding whether to grant the waiver. Without a qualifying relative, meeting eligibility for these waivers can be challenging or, in some cases, impossible. A crucial part of these applications is requirement to demonstrate extreme hardship to the qualifying relative if the waiver is not granted. Extreme hardship can be complex to prove as it goes beyond ordinary emotional and financial struggles. This might include severe financial impact if the relative relies on the applicant's income, medical conditions that would worsen without the applicant's support, or emotional hardship that could affect the relative's mental health or well being. Each type of hardship must be supported by specific documentation, such as financial records, medical records, a psychological evaluation, and more. Expert statements like those from doctors, psychologists, or financial experts can also add weight to the case, helping to paint a picture that is complete, that showing why separation would create extreme hardship. Altogether, these elements form a compelling case for why the waiver is necessary, increasing the applicant's chances for overcoming their grounds of inadmissibility. In summary, waivers play a vital role in overcoming barriers to admissibility in the immigration process. When individuals face obstacles like past immigration violations, criminal convictions, or health related issues, a waiver provides a legal path forward by addressing these grounds of inadmissibility. Each type of waiver has unique requirements, but demonstrating extreme hardship to the qualifying U.S. or lawful permanent resident relative, such as a spouse or parent, or even a child in certain circumstances, is often a crucial element. This hardship must be compelling and well documented, showing that the family member would face significant difficulties without the applicant's presence. Ultimately, a waiver can be the determining factor that allows someone to stay in or enter the U.S. legally, reuniting families and creating opportunities for a stable and secure future together. If you or someone you know is facing an immigration issue that may require a waiver, don't hesitate to reach out. Navigating waiver applications and the broader immigration process can be complex, and having the right guidance can make all the difference. Whether it's understanding eligibility requirements, gathering compelling evidence, or addressing specific legal challenges, professional support can help make the path smoother. I want to thank you for watching. Be sure to subscribe to our channel for more insights and practical advice on immigration topics, from waivers and visa options to application tips and policy updates. Hit the notification bell so you'll never miss out on our latest content designed to help you and your loved ones achieve your immigration goals. Stay tuned, and we'll see you in the next video.